car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis Wright.
Hello and welcome into The Attorneys. Thank you so much for joining us tonight. Got a really interesting topic of conversation that affects a whole lot of us. Chances are what we're talking about tonight, premises liability, in some shape, form, or fashion, either you or somebody you know has been impacted. We're going to cover a lot of ground today, but a couple of ground rules. We have attorneys from Hollis Wright standing by right now. All you got to do is pick up the phone, give them a call, or text them, get in touch with them. Live attorneys standing by right now, and we always love for you to be a part of the conversation, and there are ways for you to do so at the bottom of your screen. Leading our conversation, he's the managing partner at the firm Hollis Wright. Josh Wright, good to see you,
Good to see you too. Hope you're doing well.
Doing well. How are you doing?
Fabulous. Did you have a good week?
I did. How about you?
We had a great week. You know, David, tonight we're talking about premises liability. There are some very interesting statistics. 31 million people per year will be injured through no fault of their own on a premises one way or the other. And there's some really complicated areas of the law that fall within the ambit of premises liability we're going to be discussing tonight, and kind of what to do if you find yourself in one of these circumstances. We're lucky tonight because we brought Craig Shirley from our law firm. First of all, welcome.
Thank you, Josh.
Craig's first show with the firm, and just joined the firm, and we're super excited.
Just throw him right in there.
That's right. You know, that's the way we did it. In fact, we were going to let him be the host tonight, and we'll let him be the expert. But Craig, welcome to the show, and so glad you're at the firm.
Yeah, thank you so much. Appreciate you having me.
He's got pretty awesome background.
Can I ask?
Yeah, please.
Can I just, since it's his first show, let's put him right on the spot.
Right?
So, Craig played baseball at Auburn.
Yep.
Okay. Could you imagine, Josh? Now, you were a baseball player. Yeah. Like, are you 6'5"? How tall are you?
6'4".
Okay, imagine facing Craig on the mound, throwing a fastball.
I'd be bunting. I'd be bunting.
Good Lord.
I'd try and use those wheels, that speed. That speed.
Well, yeah, good for you. I'm glad you're doing this now, but I would have hated to have faced you.
Well, he's going to be a lot better on our team on the show than against us on the mound. But,
there you go.
Craig, welcome. Let's talk. Let's kind of jump into this just a little bit, because I know this is an area of the law that you've got several cases right now, just even at our firm. Kind of explain, if you will, in general terms, kind of what premises liability generally is.
Sure. So premises liability are claims where a person has been injured on the property of another that was based on a defective or an unsafe condition on that person's property. And those claims are valid when the property owner either fails to remedy that defective or unsafe condition, or they fail to warn the visitors that are coming onto their property of that defective or unsafe condition. Yeah. We see these claims a lot as well for property owners that fail to adequately provide security for the visitors that come onto their property. So there's a wide gambit of areas and nuances of this premises liability
David,
law.
this can impact somebody, you know, tripping and falling in a public location on a premises. It can involve, as Craig was alluding to, you know, not providing appropriate security on a premises. It can involve bars, restaurants, those types of things. So it's a very wide topic.
You know, we've done these shows every now and then, and as a business owner myself, you guys are business owners yourselves, I like doing this show because it's good for the viewer that may have a case. Yeah. There is value to what we're going to talk about today. But if you are a business owner or a manager or a supervisor and you're leading a team, what we're going to talk about tonight could save you and your company a great deal of money, heartache, and hardship as well.
There's no question. And let's jump into kind of the general categories. We've got licensees, invitees, and trespassers. Let's talk just a little bit about that. And I don't care what order we do it in, but this is kind of an interesting area of the law because there are different standards based on what category you're in.
Right, and like I said, the nuances of premises liability law kind of starts with your status of how you're categorized as when you come onto somebody's property. So there's three basic types that Josh mentioned. We have invitees, licensees, and trespassers. Okay. So we'll start with an invitee, and that's a person who enters the property of another person for the financial benefit of that property owner, or what I'll sometimes refer to as the defendant. And so think of it as an instance of a customer in a retail store. A customer would be an invitee.
All right.
And so like Josh mentioned, there's a different standard of care. So to invitees, the defendant or the store owner owns a duty of reasonable care to the invitee. They owe a duty to maintain their premises in a reasonably safe manner to make sure that their property is in a safe condition for those invitees. Secondly, we have licensees, and it's a little bit different. A licensee is a person who has either an express or implied permission to be on the property of another. And so I like to think of it as a social guest. If you were to go over to a coworker's house for drinks, for dinner, for any kind of social event, you'd be classified as a licensee. And it's different from an invitee because a defendant or property owner, the standard of care changes a little bit. And so towards licensees, the property owner just owes a duty to warn the licensee of any hidden dangers or defects that the property owner knows about that the licensee does not know about. So it changes a little bit.
Okay.
And that's different for a trespasser. So we all know that trespassers are people who unlawfully enter the land. But a licensee can also become a trespasser. Like I said, for a licensee, you have that permission originally to be on the property. But let's say the property owner revokes that permission, asks that social guest to leave. Well, if that social guest then remains on the property, that licensee now becomes a trespasser. So it not only applies to people who unlawfully enter the land, but then unlawfully remain on the land when asked to leave. And in that situation, the property owner generally owes no duty to the trespasser. The only duty they really have is to refrain from willfully or wantonly injuring the trespasser that's on their land.
And let me jump in on a couple things. First of all, you understand why we retain this guy, by the way. He's solid. So, you know, people can go from one category to another, as Craig mentioned. And let me just give you a good example of, you know, you look at a trespasser and say, well, that's a person that's unlawfully on the premises and they must have done it intentionally. That's not always the way that it works. Think, for example, just in context, a simple example of a hunter who thinks that they are on one property and accidentally works their way over to another property, and they technically are qualified as a trespasser. Now take that property where that property owner was aware, for example, that there was a well on that property, and or there's a pitfall or some other condition that's dangerous, bear traps, whatever it may be. There may be responsibilities that property owner may have, even for somebody who innocently becomes a trespasser. Now, we're not saying that you know, that property owner has got some direct responsibility to make sure they notify those individuals that are trespassers every time. As Craig rightly pointed out, really all you have to do is make sure that you don't willfully and wantonly injure somebody, whether they're innocently a trespasser or they're intentionally a trespasser. And so a lot of times the key is getting advice early if you've run into this circumstance, or if you've got questions, call, get some free advice to be able to make sure that you protect yourself from certain circumstances. Now, when we come back, we're going to talk a little bit more about the nuances of these three categories, but also some common examples that we see in the practice of law where people are injured at no fault of their own, where they've got a viable cause of action, and how they kind of pursue and start that case.
Okay. All right. We're stepping aside. Our first break of the evening. As we do so, reminder, social media, Facebook, Twitter, wherever you are, Hollis Wright is. Just search Hollis Wright and you'll find them there. A great educational, informational follow on social media. Stay tuned. We're coming right back.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
That we would be able to use the resources of the many lawyers we have at this law firm to create a plan that had a lasting impact that also gave back to the community at the same time. And I think we've done just that with the attorneys.
Welcome back into the Attorneys. Going to get back to our conversation here in a moment. Just want to remind you, though, attorneys from Hollis Wright are standing by even as we speak. Take advantage of that opportunity to get some free, confidential, and off-air legal advice. It's yours for the taking, so take advantage of that opportunity. Josh?
People sometimes challenge that. They don't realize that we're going to respond to texts and Twitter and Facebook.
One of the most asked questions I get.
Yeah.
Is Josh Wright really nice? Yeah. That's number one. And then number two.
I hope he answers, yeah, he actually is okay.
On both fronts.
Yeah, that's good. Yeah. All right, so Craig, let's talk a little bit about, you know, a lot of times we see circumstances where there's a municipality, whether it's a curb, a roadway, a county based on county roads and potholes, those types of things. How do those claims kind of get created where there's a premises component to it, and what do you have to do to make sure that you protect your interests?
Right, so the premises component of it is, you know, you're walking down the sidewalk, the concrete's uneven, it's crumbled, or you walk into a government building, the flooring tile's broken or uneven, and you slip and fall and injure yourself. There are special rules for that, and like you mentioned before break, it's very important to contact an attorney early because of those special rules. For injuries that occur on municipal or state government properties, sometimes the time to file a claim is increased or sped up. For instance, you have to file a notice of claim within 6 months. Sometimes it's out to a year. And that's different than your normal personal injury car wreck accidents where you normally have 2 years from the date of the injury to file a lawsuit.
Yeah, key is getting to a lawyer quickly and
right.
as fast as you can, because if you're involved with an event, not just premises, but any event where a county municipal employee, those types of folks are involved, you may very well have to file those notice of claims through counsel. They're very easy to file, but if you miss that, you're going to lose your municipal claim or your county claim, your governmental claim, so you want to make sure you get to counsel early.
Let me ask you about stairs, escalators, that whole arena, because so often there's actually a store that my wife and I like to go to in an old building, and there's an upstairs, and the railing is kind of crickety, and the stairs are old, and the carpet is worn. It just makes me nervous every time. Are there different sets of rules, or what are the businesses' maybe obligations when it comes to stairs, escalators, that sort of thing?
Right. So generally the businesses have a duty to maintain those stairs in a reasonably safe condition. Like you said, there's a wide variety of stair injuries. You have it where escalators are not working properly, or you have a stairwell that the railing is loose and somebody pulls on the railing and slips and falls. We've seen it multiple times to where the elastic or the strips on the stairs are worn, and now the stairs are slick and somebody steps on it and slips and falls. See it all the time. We also have instances where the stairs aren't up to code. There may be the height's not to standard, or they may be missing a stair altogether at the last step. We've seen it to where clients have been injured where they've stepped on a stair and the stair just collapses under them and they fall completely through the stairwell. So there's a wide variety of ways that people can be injured on stairs: escalators, stairwells, steps, up to apartment buildings, you name it. We've seen it.
And so, Craig, let me follow up on that. You talked a little bit earlier about invitees, licensees, and trespassers. Your inquiry in those claims when they come in for you to evaluate starts at that level, doesn't it?
Absolutely.
At that person may be using an escalator at a mall, maybe walking on a stairwell at a business where they're an invitee versus a licensee or trespasser, and what condition that stairwell has to be in, what condition that escalator has to be in, et cetera, is based on kind of the category that that business is in. That's the initial inquiry where you're evaluating. We've also seen a lot of cases, and I've handled a bunch of these cases, involved elevators. We think that every time you get in an elevator, it's safe. Well, you know what, for the most part, that is the case. Right. And that's hopefully going to be the case the rest of all of our lives. But there are circumstances where, especially in work environments, where there are circumstances where they're building buildings and they have temporary lift mechanisms or temporary elevators. We see all sorts of things that happen in those. And it starts with the same inquiry that we've already talked about invitees, licensees, et cetera.
Is it enough? I see this a lot. Watch your step. You see that all the time posted all over everything. Is that enough for a business just to put that out there?
Sometimes it can be. Oftentimes it's not. Right. We've seen it to where, like you said, watch your step isn't good enough if you can't see the sign, right, or the sign's the same color as the wall and it blends in, or if there's just a hidden defect, it's watch your step, but there's a nail sticking up in the side of the step, and you hit the nail and fall on it. So sometimes it can be enough, oftentimes it's not.
Yeah, and you know, consider this too. The law is smart. It's intuitive. It's smart enough that there are certain risks as consumers going into businesses, restaurants, etc., where the law is going to dictate that you're on notice of potential injuries. There are certain rules, for example, associated with rainy days, and whether you are within a certain distance of a front door, a tile surface, etc., where the law is going to protect property owners in circumstances where someone should have been aware that there could be an issue. Really what we're dealing with a lot more than that is circumstances where you've got a grocery store, for example, who knows that there's a problem, someone's supposed to clean it up, they don't, right, someone walks by, it's not something they can see readily, they slip and fall. It's an escalator that was defective and a kid's shoe gets caught in the escalator because there's a lip on the escalator that's not within code, and all of a sudden the child's leg is injured. Those are the types of things we're seeing a lot. The law, though, is intuitive enough and smart enough to dictate that there are certain things that we know. I'll give you another good example. You know, if someone comes into you and say, well, I don't know what I fell on. I'm not exactly sure. It was at night, but I couldn't really see it. Well, the law basically says if you don't know what you fell on, if you can't identify that defect, you don't have a viable cause of action. So there are some defenses that property owners have, but it's one of the reasons why you want to get someone like Craig, someone like our firm, to be able to evaluate these cases. And a lot of times the answer is, hey, look, I'm sorry, but you don't have a cause of action because the law doesn't allow for that.
Yeah. We need to step aside.
Yeah. When we come back, let's talk a little bit more about some of the common examples that we're seeing out there now.
All right. We are stepping aside. Our final break of the evening. We'll be right back after this quick break.
I'm Josh Wright with the law firm Apollos Wright. As with any industry, it's important in the legal world to hire an attorney that is knowledgeable and has a track record of success. But with so many attorneys out there and so many different types of cases, how does someone decide the right lawyer to hire? In this week's Legal 4-in-1, we're answering the question, what should I consider in hiring an attorney? In-state versus out-of-state, big firm or little firm, recommendations from friends or family, the internet, the phone book, or TV. With so many choices and so much information, it can be an overwhelming task trying to make the right decision. To complicate things, choosing a lawyer is an important and sometimes life-affecting decision and should not be taken lightly. So how do you select an attorney? First, do your research. Look the firm up on the internet. Learn about the cases they handle and the results they get. Second, find out what clients are saying about the firm. Many websites provide client testimonials or have a star ranking system. Use those to your advantage. And finally, talk with a lawyer from their office and ask them questions. Questions about the volume of cases they handle. Do they return phone calls? Are you just a number or a client that gets the attention you deserve? Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys right here on WVTM 13.
Welcome back into The Attorneys, our final segment right here. So if you want to take advantage of the opportunity to speak with an attorney from Hollis Wright, attorneys who are standing by live right now, you got just a few minutes to do that, about 7 minutes. Let's get back to our conversation. A question we've got here, and because there are several, we're going to kind of group it, broaden that a bit. So let's say I've been injured. What do I need to prove to have I have a good claim? All right.
There are 4 basic elements for a premises liability claim. And so first, the thing you have to prove that the person causing your injury, the defendant, actually owned, occupied, or leased the property or the premises.
Okay.
Second, that the defendant was negligent in their use of the property. And third, that you, the plaintiff, were actually harmed. And then the last element is that the defendant's negligence was a substantial factor in causing that harm. And like we've said many times already on this show, it's very important to contact an attorney early, because it's so super important to gather that evidence as quick as you can and as much evidence as you can. So we have clients ask all the time, what can I be doing to help prove my claim or process my claim? And we tell clients all the time that it is super important to stay organized, keep your medical records, your bills, your hospital visits, keep them all in one place. I tell clients all the time to keep a journal to document what medical provider you saw, what they treated you for, when you saw them, when they need you to be back. Are they going to refer you to somebody else? Keep all those notes. But really, one of the most important things for the premises liability claims are photographs.
Okay.
And really taking a picture of the area where the person slipped and fell or where the injury happened. Taking a picture of what it looked like immediately after that person was injured is very valuable. It doesn't give the defendant time to come in and remedy that defect or change it or alter it or wipe away the slippery substance or clean up the water that you slipped on. Yeah. It allows us to see exactly what that area looked like when you fell, and is very, very advantageous.
Well, and it puts the lawyer at in a good position too, to be able to evaluate that case, give good advice, and be able to assess whether or not it's a case you can prosecute or not. And that's really what you want. So doing some of your initial work, whether it's pictures, maintaining a diary, documents, etc., those things will help you kind of have a jump start on your claim and help a lawyer be able to quickly evaluate it. One of the things, Craig, you mentioned is proving that the entity was negligent in their conduct, and that goes back, does it not, to the various categories, whether you're an invitee, a licensee, did they act reasonable under the circumstances, was the premises kept in a reasonably safe condition, etc. That's one of the things that we're going to have to prove in those claims. So, hey, one question I've got for you is, you mentioned people that lease the premises. Let's assume that I'm renting a premises, have, for example, a dog who has propensities to bite someone. Can you be responsible as a lessee of that premises if there is an event that happens?
Oh, absolutely, yes. So if you rent an apartment from the tenant, from the landlord, excuse me, you are the tenant, and you do have a dangerous dog and that dog does bite and injure someone, then absolutely you can be responsible. Yeah. And inversely, the landlord can also be held responsible in certain situations. Yeah. If the landlord knew that the tenant had a dog with dangerous propensities, a dangerous breed, or that they knew that the dog had bitten somebody previously, and that dog does turn around and bite somebody else and injures that person, then both, in that instance, the landlord and the tenant could be held responsible for the injuries. What
is the general time frame from the time of one's injury that they have to file a claim in Alabama? How does that generally work? Can you explain that?
We touched on it earlier. It's normally in Alabama, it's 2 years from the time of the injury. But again, the importance of an attorney getting in and navigating those rules, because we talked about the government entities and municipality entities and stuff, so it changes. But generally speaking, if you're injured from a slip and fall or on somebody's property, you generally have 2 years from the date of injury to file a lawsuit.
And Craig, if someone comes in and expects the day they file the suit gets resolved, it doesn't work that way, does it? It does take some time in the legal system. That may not be because the lawyer, is not diligent. It may simply be the system is a little bit slower.
Right, absolutely. Sometimes these cases can take more than a year to process. And a lot of it is just, your attorney making sure that your injury and everything that the lawsuit is going to cost in itself has been determined. There's a lot that goes into these claims, like I said, those 4 elements that we have to prove, a lot of investigation, a lot of reviewing photographs, talking to witnesses. So yes, it's not the fact that we file a lawsuit and it's over with. We get that question a lot, but it does sometimes take more than a year to process these claims.
David, and I also want to talk about this because, the typical person sitting on a couch right now may think, well, this is just a call-in show on the issue of slip and fall. Well, that's not really the way that this works. I'll give you some examples of cases we've actually seen in the real world. An elderly person slips because there is a missing final stair that a landlord was well aware needed to be replaced, had a series of memos back and forth with the maintenance about making sure that final step is put in. Maintenance never gets around to it. Then maintenance quits. It never gets done. That person falls, hits their head, ends up having a stroke, and passes away within a month of the time that they have a stroke. I'm just giving you an example of how serious these things can be. Not always, but how serious they can be. You want to get to a lawyer quickly to be able to evaluate claims because that person should not have met their demise the way they did in that circumstance. So we're here to help you in circumstances if you have serious problems.
Yeah. Really interesting topic of conversation. Could go on for much longer, but we've got about a minute and a half, and I want to give both of you just time for a final thought real quickly. Craig, and if you would, you go first, please.
Yeah, so again, these premises cases are tough to prove, and it's important to contact a lawyer to help you navigate those rules and evidence that needs to be gathered. So yes, please give us a call if you ever are injured on a premises owned by somebody else.
Yeah, and what I would say, David, is you want someone to evaluate these claims, and our firm is someone that can do that for you. And a lot of times the answer is going to be, hey, look, the law does not dictate a cause of action right here for you. And here's why. Because there's established case law in this area that dictates that, hey, we can't be successful. However, there are going to be circumstances where you can. So part of the process of working with law firms that work on a contingency fee relationship is that you can go to them at no cost to yourself to get free legal advice to understand whether you have a cause of action or not, and then potentially to act on it to the extent that you do.
We're out of time, but I appreciate you being with us.
Good first show, my man.
Thank you.
Good job.
Welcome to the team, for sure. Love having you here. Appreciate you guys being here, and you all as well. Thanks so much each and every week. It really does mean a lot for you to spend some time with us on these Sunday nights. We appreciate you being with us, and again, thanks so much, and we hope that you'll join us again next week, and you have a great week this week. We'll see you next time on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.